Well, thank you so much, Mr. Chairman. And I must say it was a long trip, but it was really worth it. I mean, Alicante is just such a beautiful place. It doesn't matter how many flights you have to take to get here. It was just lovely. And I would like to also mention that I was very pleased to hear President Campinos' remarks this morning, because I think he really accurately reflected the spirit of cooperation and collaboration that has existed at a heightened level for the past few years between OHIM and the USPTO, and that's because we all recognize that we have so many users in common, and so we want to make things as easy as possible for users, recognizing, of course, that our systems are not always the same or capable of being harmonized, but we're looking for places where we can harmonize. And so with that in mind, I wanted to just talk about a few things today. I'm going to give you some performance data, some metrics that we use at the USPTO, give you a little bit of background, talk about a couple of issues that I think foreign practitioners do ask about, so I thought I would mention them, and then talk about a couple of new initiatives that we have come up with, and just very recently, so it'll be hot off the presses for you guys. So just to give you an idea, the USPTO actually has more than 11,000 employees. And as you see in your note, we have 679 trademark employees. So we're a pretty small part of the entire USPTO, but we're extremely important. Nobody should forget that. We have 410 examining attorneys, and to be examiners, you have to be an attorney in the in the United States. And 85% of the examining attorneys telework; they work from home full time. So that's we have quite a robust program. And in fact, of the 11,000 employees at the USPTO, I believe more than 5,000 of them work at home full time. So it's been a great program. It's actually been an excellent tool to attract and retain the highly qualified people that we want to have at the office. We have examining attorneys in 25 different states in the United States. So they're all over the place, and we utilize collaboration tools like WebEx in order to bring people together for meetings and things like that. And occasionally they come into the office, but not too often. This slide just shows you that the USPTO was ranked at number 5 in the entire federal government out of 292 sub-agencies as the best places to work. And this was done by a nonpartisan organization, and it was based on surveys that were sent to every federal employee in the United States. So we're very proud of that, and we think that our lifestyle benefits that we've developed over the past few years have contributed to that, especially our telework program. We also have a fitness center on site for people who do come into the office. We have child care center, and we have a very nice cafeteria. And if you just look at the pyramid there that you see the bottom is, we were at 172 just 6 years ago. So we've really risen up. And again, I think that's the result of telework. I wanted to give you some information about our application filings. We're having a record year this year. If you can see the bar all the way to the right represents 2013. We go by fiscal years, so our fiscal year is almost over. It ends at the end of September, and we have projected around 433 new classes filed, and that is a record. That's a lot of applications. And if you look at the chart, I don't know if you can see in the fine print that in fiscal year 2009, with a drop in the economy, we took a pretty steep hit on new trademark applications, but ever since then we have been recovering each year with a good percentage, and I mean, maybe 4 or 5% increase. And we're projecting the same thing for the next few years, by the way, and so we will be doing some hiring to increase our numbers for examining attorneys. I'm going to give you some information now on our performance results, and these are really important to the U.S. We report these out to Congress. We report them to Department of Commerce, which is, we are a part of the Department of Commerce, and we report them to the Office of Management and Budget. So they're pretty important. The first is e-government, and e-government means the percentage of trademark applications that are filed completely electronically from beginning to end. And so why do we care about this? Well, electronic communication and electronic filing is faster, it's more efficient, it's less prone to human error, it benefits everybody. What you as the applicant put in your application form or in your submission is what actually gets uploaded into our system, rather than having to rely on people key entering things. Now, 98% of our new applications are filed electronically. So we're not talking about new applications. We're talking about submissions throughout the application and registration process, and currently we're at 78%. We're trying to figure out ways that we can improve our systems in order to increase that percentage. So we've had focus groups, we've taken people's suggestions, user suggestions on what will make people use the system more and not rely on paper communication. So that's still in the works. We're hoping to increase that. I'm sure we won't get to 100%, but hopefully we can get closer to the 98% for new application filings. The next slide has to do with pendency. So pendency from the date you file in the USPTO to when you hear from an examining attorney, your first office action, and we're a little bit under 3 months on that, and that is within our target. Our target is a range from 2.5 to 3.5 months. And the reason we have that range is that we want to give people a timely communication on what the disposition of their application is, but we work on a production system of many, many applications. We have an inventory of about 100,000 applications. We have, as you know, over 400 examining attorneys. We have to have a continuing inventory of work for them. So the 2.5 represents about as low as we want to go on that inventory, so that if filings drop, we won't have to fire people or do something else drastic. We can kind of go with the flow and continue our examination process. And in coming up with this first action pendency number, we actually did consult with our stakeholders in the United States, and everybody agreed that this was actually the proper number. Now, for disposal pendency, and that's from the date of filing until you get a registration or the application abandons, or you get a notice of allowance if you're filing under our intent to use section. And that is generally around 10 months. That's the average. Of course, it depends on your individual application. Now, if you have a case before our Trademark Trial and Appeal Board, or if you have a suspended case for whatever reason, those cases are not included in this mix. But if you don't have either one of those, you can expect on the average of getting a registration in about 10 months if you're going to get one. Quality is another thing we measure, and as President Campino said this morning, it's important to measure quality, to make sure that you're getting good quality. And so we've been measuring quality, and the first two items you see are first action compliance and final action compliance. And those simply mean, did the examining attorney make the right legal decision? Yes or no? We recognize that trademarks are subjective, of course, but within that context, did they make the right legal decision? Now, the next box, exceptional office action, includes the legal decision, but, and this is a new measure, by the way, it's only 2 years old, we've actually gone above that. We're saying, was the right legal decision made, and was the search proper, and was the writing the best it could be, was it clear, and was the evidence appropriate? So we've raised the bar on quality, trying to figure out ways that we can improve over and above what we've already achieved. And so we're very happy about that measure. Examining attorneys are rising to the occasion. We've reached almost 35% so far, which is a lot when you consider that in order to be included, you have to meet all of those criteria, not just one. Now, how did we come up with those criteria? Well, we actually use our stakeholders, our users, to help us validate quality metrics. And the way we do this is we and they volunteer. We don't make them do this. We give them a number of cases to review that have already been rated by our Office of Quality Review. And they tell us, do they agree with us? Well, what would they think about the case? And we don't give that feedback to our examining attorneys directly. What we use it for is to make sure that we're looking at things properly from a stakeholder perspective. And it also helps us identify areas that we might need to have a little more training in. So we've been doing that for a few years. And what we found is, in general, our criteria and our metrics do match what our stakeholders want. We have another process. We're refreshing that right now, so we'll see what the results are. Another way users provide us input is through our online collaboration process. Now, if you've been on our website and if you use the Trademark Manual of Examining Procedure, you may know that we have an online collaboration tool in connection with that that gives you the ability to comment on our manual. And I know this morning one of our speakers from OHIM talked about getting input and before drafts are made final. We're doing the same thing through this collaboration tool. We're considering all comments that are submitted. We also post our examination guides before they're in final form. So right now we have 2 examination guides posted. One is on geographic certification marks, and the other is on registration of top-level domain names under the new GTLD expansion. So I invite you to please take a look at those and send us comments if you have any. The EU OHIM has commented on the geographic certification guide. We've gotten comments from INTA on both of those guides. And we're happy to take individual comments if anybody wants to do that. We also are consulting with our users, and this, I think, is a great project. We're consulting with our user groups, specifically INTA and IPO, which is the intellectual property owners. I'm not sure that they reach as far as Europe, but they're a very big organization in the US. And we're looking to update and improve entries in our Identification of Goods and Services Manual. Well, why are we consulting users? Examining attorneys are not experts in industry. We want to get some expert opinion, especially in areas of rapidly changing technology. And so we're looking at 3 specific areas to start: social media, finance, and computer terminology. And we're going to try to get some good information from the experts so we can provide our examining attorneys and we can provide the public with better identifications of goods for them to put in their applications and registrations. Just a couple of words about Madrid Protocol, just to give you some information. The international applications that U.S. applicants file through our office into the International Bureau is fairly low. We would like to see it higher. So far this year, we've got around 5,600. The requests for extension of protection coming into the U.S., a little over 12,000 so far this year. And I think we would like to see more use of Madrid. I think one of the issues in the United States, and you probably can relate to this, is that U.S. users don't really want to be stuck with our identification requirements when they go into Europe and other countries. So rather than filing through Madrid, they maybe would prefer to file in a CTM or into the national offices. And so that's an issue we're dealing with, and we have some thoughts about how to improve that, and we're working on that right now. Okay, this is a question that we get quite often, and I thought I would give you some information on. And it's basically who can represent others in the USPTO. The answer is generally it's restricted to U.S. attorneys, and I will explain. So, of course, the owners of the marks themselves may represent themselves in trademark matters, or a qualified practitioner may represent them. So what's a qualified practitioner? Generally, they're members of a bar of a state in the United States. We have a couple of exceptions, and those apply to Canadian patent agents who are registered with our Office of Enrollment and Discipline and are in good standing, and that's for the limited purpose of representing parties who are located in Canada. We also have an exception, again, for Canadian attorneys or agents who have been granted recognition by the director for the limited purpose of representing parties located in Canada. And finally, and I bet none of you know this, we have an exception for individuals who are not attorneys but were recognized to practice before the USPTO in trademark matters prior to January 1st, 1957. So if anybody falls into that category, we let them represent, but I think the group is a little small at this point. And so I know that people have questions about these procedures, and I would like to tell you, if you do have questions, we have a mailbox, and the mailbox is good for a lot of things, not just this topic, but you should take it down. It's tmfeedback@uspto.gov. tmfeedback, one word, at uspto.gov. And if you have a question about correspondence procedures, representation, or any other issue, we look at the mailbox every day, and we always get routed to the right person, and you will always get a prompt response. So with that said, what are some of our correspondence procedures? If an attorney has appeared, we will correspond only with that attorney or a qualified member of the same firm. So for pro se applicants, we will send the correspondence to their designated correspondence address or to a domestic representative if one is designated. You're not required to designate a domestic representative. And we may send the official correspondence by email, but we will only do that if you authorize the email. Now, I do want to say that although we only recognize one official correspondence address, for email purposes, you can actually enter up to 4 additional courtesy copy addresses. So that's a way for you to get notified, even if you're not directly representing your client, for you to get notified in real time of all of the PTO actions that are taken. For Madrid Protocol applications, we will send the first office action to the IB, and subsequent office actions are sent directly to the applicant's correspondence address. Now, what if there's an address change? So for the extension of protection request itself, all of the address changes would come directly into our office. If it's an address change for the international registration, that must go through the IB. So that's good to keep in mind. Now, I'm leaving correspondence addresses and moving on to a new topic, and that is deceptive trademark solicitations. And we share an unfortunate problem with many of you here, and that is that deceptive solicitations are being sent to trademark applicants and registrants using data from our database. And so what are we doing about that? Well, and it's a problem because sometimes they look very official. They're asking for fees. People are genuinely misled by them. We don't have enforcement authority in this area. What we can do is, if it's clearly confusing, we will send a cease and desist letter. And we have, and we've gotten good results from that, where companies, entities have stopped what they were doing. We're also including a warning in every application filing receipt, whether it's filed online or on paper. And so hopefully applicants are looking at that language. And then when the registration certificate is issued, we insert a bright orange warning sheet with that. And today all of our registrations are issued on paper. So anybody getting a registration gets a bright orange warning sheet. Has anybody here gotten that? Yes, okay, good. Thank goodness. And the other thing we're doing is we have a notice posted on the website with actual examples. We have about a dozen different examples of actual solicitations that have come to our attention, and we will put one up. If somebody gets one and sends it to us and it's misleading, we will put it up on the website. Of course, people have to know to look at the website to see it, and that's why we include the warning letters, but we're doing everything that we can do. Now, what I would ask you to do is to tell your clients, if something is from the USPTO, it must say uspto.gov. Otherwise, it's not from us. If they get something from any other URL, it's not from us. So that's another way that people can be vigilant about making sure they don't respond to these I was going to say scammers, but I won't say that. I'll say solicitations. Another area that I'd like to talk about is describing the goods and services in the United States. And here's an area that our practice is very different from the European practice, and we realize that people are generally not happy about that in Europe. So I thought I would, but recognizing that this is what we do, I want to go through a couple of the steps and just some of our policies on this. So as a general rule, the applicant is required to have identifications that clearly, accurately, and specifically help an English speaker understand the nature and purpose of the goods and services, and so that we can properly classify the goods and services. Why do we do that? Well, we believe that clear identifications put other trademark registrants and applicants on notice as to the scope of the owner's rights in the mark, keeping in mind, we are a use-based system. We refer people, or we ask that you look at the USPTO Acceptable Identifications of Goods and Services Manual for guidance. We have many thousands of listings in there, and we're constantly trying to improve. And in fact, if you have a suggestion for an identification that you would like to put in an application and you want it approved by us, you can send it to tmidsuggest@uspto.gov. tmidsuggest@uspto.gov. And that will also, once that's approved, it will enable you to file our T's Plus application, which is our lowest fee application. If you have an application and you're not sure how to work with the ID, please contact the examining attorney that's been assigned to the case, and they will come up with some suggestions if they can, or at least ask you more about your goods or services to help you. When we issue a requirement, the examining attorney has to inform you of the reason that the wording is not acceptable, and whenever possible, they're supposed to suggest an alternative acceptable wording for you. Okay, so here are some rules to remember. Common class headings are not acceptable. They're not. They're too broad. Common commercial names, on the other hand, of particular goods are acceptable. That's absolutely fine. And if something is refused and you believe it's the common commercial name, tell the examining attorney, and they will work with you on that. We would like for you to avoid open-ended wording like including or such as, since those are indefinite, because it doesn't restrict you to what's actually in the identification. We also ask that you avoid words like products and accessories. Those are considered ambiguous because they actually often could include items that would be in other classes. So it doesn't meet all of our requirements. Now here's something new in the ID area that I wanted to tell you about. And this, I don't know if anyone in this room has used it yet. It just went online about 2 weeks ago maybe, and it's called our ID Assistance Tool. And so when you enter in free text on the TEAS application, I'm not talking about TEAS Plus where you have to use an entry that's already in the manual, but a regular TEAS application that allows you to do free text, you will see a pop-up that tells you, is there a match in the ID manual? So you'll see that. Or is there a possible match? Are you pretty close? Or is there no match? So that saves you the trouble from having to go back and forth into the manual. And it should be very helpful. We're very excited about this tool. We're planning on making more improvements to our manual, but this was as good as we could get in a relatively short period of time as far as an IT change goes. So we're happy with it. Shifting gears now, I'd like to talk a little bit about educating the public. And I was so pleased to hear the briefing this morning from my colleague sitting to my right, talking about all the efforts that Slovakia is doing to educate the public, because we're actually engaged in many of those same things. We started in 2012 a new educational outreach program that's specifically directed to small business entrepreneurs and students around the country. And we're actually going around the country and speaking to these groups. And the reason it's new is we've had an education program dealing with schools and talking about the importance of innovation and IP, but we've never actually gone around and talked to groups of people who are just business people who don't know that they need trademark help. When we ask people if they have a business plan, everybody raises their hand and says yes when we're in a small business or an entrepreneurial club. And when we ask them who has a trademark component in that business plan, usually nobody raises their hand. So you probably all know this. There is such a clear need for people to know about the proper selection and proper protection of trademarks before they get into hot water, before they get that cease and desist letter, before they've invested their money. So that's what we're doing. We've been doing this for a year and a half, and we've talked with thousands of people, and we've gotten terrific reviews. People find it very enlightening. The other thing that I wanted to mention in terms of education is right on our website. It's our Trademark Information Network, and it's a series of videos. Most of them are very short. They're under 10 minutes, and talking about different aspects of the application and registration process in the United States. And I have heard from a number of paralegals and attorneys throughout the U.S. that they actually use these videos to help train their new employees on U.S. processes, and also to help clarify things for their clients who sometimes just, they don't get it right away. They don't understand how they're explaining it. So watch the 2-minute video, and it's pretty clear. So I invite you, if you have some time on your hands and you have a question about something with respect to U.S. practice, take a look at one of these videos, and it should help clarify. They were designed for pro se applicants, but I'm telling you, attorneys are finding them very, very useful. We have more in the works that are going to be coming out soon, so you'll see an expanded list. Next, the next outreach I'd like to talk to you about has to do with enhanced interaction with the trademark bar. So we have a two-pronged approach to our outreach. One is the public, who knows nothing, and the other is experienced trademark practitioners who we would like to have more contact with and talk to about our processes, get feedback from them, tell us what we're doing, what you like, tell us what you don't like, tell us how we can improve, what would make you use our systems more, what changes you'd like to see, and what's important to you. So we've been going around the country. We've been working with INTA on a series of roundtables, small groups, 25 attorneys or less, to really give them a chance to interact on topics of interest, exchange practice tips, and raise important issues to us so that we can hopefully do something about them. And these have been going on for the last, again, about a year and a half, and we have many more planned for the coming year. And another way we're doing user outreach is through the TM5, which used to be the trilateral when it was just the EU, Japan, and the USPTO. Now we've added China and Korea, so we've got some very important participants in this collaboration. We meet each year. We have some in between meetings, but our annual meeting will be in Korea this year. And importantly, we have user group input into those sessions. We've started doing that a couple of years ago, and it gives users the opportunity to talk to all of the offices about their practices and to comment on some of the projects that we have been working on. And so we find it extremely valuable, and we're getting good feedback from our users on this. Here's another new product that we're coming out with, and this will be at the end of this month. It will be deployed, and it's our new electronic official gazette. How many people in the room here look at our official gazette? Okay, one. Okay, so our official gazette, which comes out every week, has all of the published marks. Right now it's in PDF format, which means it's just like a book, but it's online. So it's not that useful. I mean, it's okay, not very useful. It's hard to search, it's hard to do anything except just leaf through it like you're looking at a book. So we're redesigning it. We used to have a paper version, and we got rid of that. So that's giving us the opportunity to redesign it into a web-based format, which we're doing, which will be completely searchable. It'll have wonderful features. You can search a keyword, so if you have a particular medical condition that you're interested in finding anything related to that, you can put that in there. You'll be able to search 5 official gazettes at once, the most recent one and the 4 that came before it. You'll be able to send links to your clients on any mark that you find. You'll be able to create collections. It's really amazing what they've come up with. We've spent the better part of a year developing it, and it should be ready for actual release to the public at the end of September or at the very maybe beginning of October. So we're very excited about it, and I hope that some of you take a look at it, and I hope you find it useful. And if you'd like to know what we're doing at the USPTO, you can actually sign up at our subscription center at our website, www.uspto.gov/subscribe. And if you do that, you'll get a notice when the new official gazette comes out. You'll get a notice about various examination guides. I promise you, you won't get a notice like every 15 minutes. You'll just get the important things. So it's a good way to keep up with what's going on without having to constantly think about looking at the website. So consider signing up, and I think you'll be glad you did. And that is the end of my presentation. I don't know whether we have time for questions, maybe.
You have a few minutes with us before you?
I do.
So, first of all, let's thank Debbie Cohn for her presentation. Thank you very much. Very instructive. Can I ask you something? If I represent a client in Europe and I file a trademark in America directly, which I apparently can, will the USPTO communicate with me, or do I need a local lawyer?
You need a local lawyer.
Why that?
That's our rules. I mean, I'd have to look the rule up to give you the exact language, but that is the rule.
And if I'm an international owner of an international registration, having designated the United States, and you told us the first objection will go to the International Bureau, obviously. And then the reply will have to come from the proprietor of an international registration. Can you submit it directly, or does he again need an American lawyer?
No, we will always communicate with the applicant. They don't need to have an attorney. We have many applicants who don't use attorneys. We don't recommend that, but we've tried to make our system accessible to everyone. So yeah, and in fact, you can have the correspondence address be whatever you want. It's just that we won't take amendments from a non-U.S. attorney. In other words, you can't actually prosecute the file.
You can answer, but you cannot prosecute.
Well, no, you can have it sent to you, but you can't prosecute.
You can't prosecute,
yeah.
Okay. I mean, this is of course, I'm a little bit joking, because I know, of course, that every country in the world requires a domestic representative for a number of reasons. Among them is the ease of communication by the office with the applicant. The other is, of course, to protect the business of local representatives. In Europe, that has changed because the Commission has brought cases against member states when they required a local representative. Now it's in most situations sufficient if you have a European representative anywhere in Europe. So that's, of course, your turn. Anyone have any questions for Ms. Cohn? Herr von Kapf, please.
Thank you very much. I like when you said describing goods and services in the US, the general rule is that they must be clear and precise, more or less what the Court of Justice told us as well. My question is, later your system has a big difference because then I understand the trademark must be used. How do you examine that exactly? How does it work in practice? What do the parties have to declare? How much time do they have to show use? What do you examine actually? To what extent the use must correspond to the specification? Could you explain that more?
Yes, sure. There are two sections of the statute that a U.S. user will file under. The first is use-based, so you have to show what we call a specimen of use. And you can file international based on use as well. You can show a specimen of use. We require one for each class. So you can have, let's say, 10 things in a particular class. You have to show a specimen for one of those things to show how the mark is being used. Now, if you file based on intent to use, which is another section of the statute, you don't have to show us use right away. We will examine it and then publish it for opposition, but then you have to file your specimens of use before we will register it. So it's one way that we are trying to help owners who maybe don't know if they want to invest a lot of money in marketing a certain product under a certain mark until they know that the mark is registrable. So we will take it all the way through the publication process, and then you have a total of 3 years to commence using, and we ask you to file every 6 months an extension request. So we keep in touch with you. Every 6 months you have to file something with us to tell us, yes, you still intend to use it. Now, if you're filing through the Madrid system, none of that applies. So you're filing your request for extension of protection through the Madrid system. You don't have to use the mark before registration. But after the 5th year, you're still required to file the affidavit of use that every registrant, domestic or international, is required to file. So the theory is you're going to use it. You're just not required to use it to get the registration. And similarly, if you're filing under Section 44D, or E rather, of the Paris Convention, the same rule applies. You don't have to use it to get the registration, but you do have to use it before the affidavit of use is due in our office. So I don't know if there were other questions in there that that I haven't answered for you. Is there something else that you would like to know?
How would you sanction if someone gives a affidavit which is unclear and maybe does not really correspond to what you expected? And then you said as well, you need one specimen per class. In many classes you have very different products. So that would mean that you make the affidavit at the end for every single product, or just for one product in the class as well? How does it work?
Okay, well, the affidavit that you're putting in your trademark application prior to registration will say that the mark is in use on all the goods and services in the application. When you're filing your affidavit after the 5th year, you still have to show the specimen of use, one per class, as I mentioned, and you still have to say there's language that says you have been using the mark on all of the goods and services identified in the application. So you're signing an affidavit to that respect. There is a little bit of trust here that we're not asking you to show us a specimen for every single item. We realize that that would be burdensome, but we want you to show us at least, we want one for each class. So it's really the same type of examination before registration and after. And if you have registered, let's say you register your mark and you never start using it. Then you file your Section 8 affidavit, you don't include a specimen, or you include a specimen that doesn't support use for the mark that you had registered, we will cancel the mark. We'll give you the opportunity to correct the situation, but if you don't show us something that you've been using, we'll cancel the mark.
Does this involve a lot of work of examining such kind of evidence?
Well, we have a unit in our office. They're called the post-registration unit, and this is what they do because it's important for we have a use-based register. It's important to maintain that, and that's a very it's a big part of our office.
Would you recommend other countries to adopt a system where you have to actually provide evidence of use? For example, in the 6th year as your Section 8 affidavit, is that overall a general system which might be adopted by other jurisdictions?
I think if the jurisdiction cares about the mark being in use, then yes, I would recommend it. I think it's important for trademark owners and the public and anybody who's looking at the register to actually have an accurate picture of, in our situation in the U.S., we say it's use-based. It is use-based. We want that we want it to have some integrity, and that's why we do it.
Someone back there? Yes. Can you please state your name? I think you have to come forward, perhaps. Oh, yes.
No, it wasn't working. My name is Hugh O'Neill. Thanks very much for a wonderful presentation again. I was particularly interested in the bit where you were talking about using, your users essentially stress testing your quality metrics. And I was wondering how if you are able to kind of categorize or characterize rather how that works. And the context is just the following. I can imagine with a lot of quality processes that maybe we develop as examiners in-house, we can be kind of overly focused maybe on semantics or language, etc., whereas our users are much more pragmatic, I'd say, as a whole. So I'm wondering, when you get the feedback from your users about your quality processes, what kind of things does it tell you, if you can
It says exactly what you're saying. It tells us where the examining attorney maybe is, requiring too much. And let me just be clear. This is feedback. This isn't necessarily telling us we must change things, tomorrow. If we want to take it into consideration, but if it conflicts with another goal of the registration process, obviously we wouldn't do that. And stress test is a great way to put it. But we send them a template. So they look at this template when they're looking at the office action that they're rating. And so we'll ask them, how is it in writing? Is it clear? How is the evidence? Is it the appropriate evidence? Is it too much? Is it too little? So we ask them specific questions, and then we evaluate, and we give them the ability to give us other comments. So, for example, one comment that I remember getting a few years ago is, a lot of these things would have been better resolved by telephone. The users saw that there were a number of issues that they would prefer to get a telephone call about rather than having an office action. So we've always been very big on having examining attorneys use the phone, but what we did was, after that, we reviewed that, we agreed, and we built that into our bonus system for quality. So that's one way we used it.
Sorry to do this, but can I ask you, in general, would it be fair to say that users are kind of more pragmatic about the product in the sense that they don't have many hang-ups on maybe some of the things that attorneys tend to focus on in terms of language or maybe format and things? Is that the type of message that you get back, or?
Well, keep in mind that all of the people who are doing this stress test are attorneys. So I think that hasn't been our experience so far. Sometimes they have a different perspective because they are representing clients, and that's precisely why we want their input, because our examining attorneys are not, and they're supposed to be objective, and they're supposed to examine the case properly. But you're right, sometimes people can be a little too focused on something, and we recognize that. But I would say that hasn't been an overwhelming response.
There's another question. Yes, please. Will you state your name, please?
Hi, Roxandra Manea. I work here in the office. To come back to the specimen of use that you mentioned earlier, I was just wondering, is an undated product photograph, is that sufficient? Do you accept it as specimen of use?
Yes, as long as the mark is clear on the product, we will accept that. And don't forget, you're signing a sworn statement that this was used, at the time you say it was used. So we don't require our photo to be dated. Now, if we see a date and it looks like it can't possibly have been used when you said it was used, then we'll certainly question that. But a product photo, and that's a great specimen, a photo showing the mark actually used on the product, as long as you can see the mark clearly.
Mr. Borges.
Thank you, Debbie. If I understand correctly, it's again about quality. You don't only measure correct decisions versus not correct decisions, but you also have this exceptional compliance standard. So you also measure which decision was far above the standards that you expected. So what makes a decision exceptionally good?
Well, we actually break it down into 4 categories, and we could do more, I'm sure, but this is what we decided to do. The legal decision making, same standard as with the other measure. Legal decision making has to be correct. The search has to be a good search that would retrieve the appropriate sites, because we do relative examination in the U.S. The evidence has to be the right evidence, not not too much, and it has to be enough. But if you look for evidence on descriptiveness or genericness or anything else, you can find a lot of things that are not really appropriate to what you're trying to show. And we don't want the examining attorneys cluttering up the record with things that shouldn't be in there. And so that's the other question. And is the writing clear? Can the person who's receiving the office action actually understand it? And so we like the examining attorneys, and they do this to gear their writing when they're dealing with a pro se applicant without an attorney, to make it in plain English so that people can understand it. If they're dealing with an attorney, a trademark attorney, it still should be in plain English, but you know that there are certain things that are already known.
Thank you. And you have a clear, smart criteria for measuring these, or there is some element of subjectivity? I mean, it's more or less people who have done the job for a long while that examine this on the basis of their own experience, or are there clearly objective criteria for this?
Well, I don't think there can ever be clearly objective criteria in the trademark world. We try to be as objective as we can, but we do have an office. It's the Office of Trademark Quality Review and Training, and they do all of our reviews for us, this one plus the others. And sometimes the managers of the law offices help out as well. But generally, it's the Office of Quality Review and Training. They have guidelines. They're very well trained, and most of them have been with the office for a long time.
And everyone is happy, I assume, with their judgment?
Not always, but there's always a give and take. When somebody is not happy, we try to have a further conversation, but we recognize that.
Thank you.